Welcome back, guys. In this video, we are covering removal jurisdiction. Unlike the videos where I cover diversity jurisdiction and I have divided the videos into separate topics within diversity jurisdiction, this is the only video on removal. All right, so let's begin. In the United States, removal jurisdiction allows a defendant to move a civil action filed in state court to the federal district court in which the state is located. Federal Statute 28 U.S.C. 1441 governs removal. Here's a visual. Plaintiff files a lawsuit against defendant in state court, and defendant wants to litigate it in federal court. Can defendant remove the case filed in state court to federal court? And the answer is yes, if certain requirements are met. So how does this happen? Well, it's called removal. So let's explore this further. An action originally filed in state court may be removed by a defendant to federal court if 1. The case could have originally been filed in a federal court, and for cases removed on the basis of diversity, no defendant is a citizen of the state where the action is filed. The prevailing rule is that jurisdiction is tested as of the date of removal. Let's begin dissecting this with the first part. An action originally filed in a state court may be removed by a defendant. So what is this telling us? Only defendants may remove. So only a defendant can exercise the right of removal. If there is more than one defendant, then all defendants who have been properly joined and served must join in the petition for removal. Plaintiff sues defendant in state court, and some of the defendants want to petition to remove the case to federal court. If one or more of the defendants do not want to join in the petition for removal, then the case cannot be removed. Okay, so next. The first requirement, the case could have originally been filed in a federal court. Let's dissect this. A case can be removed if the case that was filed in state court could have originally been filed in a federal court. So the federal court must already have subject matter jurisdiction over this case. Let's look at an example. An Arizona plaintiff sues in state court a defendant from Florida. The lawsuit is based on a federal question, and the amount in controversy is $76,000. Can defendant remove the case to federal court? The answer is yes. This lawsuit right here could have actually been filed originally in federal court. So this first prong is met. What happens if there is no diversity and the amount in controversy for diversity jurisdiction is not met? In this case, you can still remove the case to federal court because no jurisdictional amount is needed for jurisdiction over federal question. That was a little bit of a trick question. I just want you to pay attention. And there's no need for diversity of citizenship when there's a federal question. In this case right here, this lawsuit could have been filed originally in federal court because there's a federal question. So the federal court would have had jurisdiction based on federal question. Now, I want you to keep in mind that the plaintiff's complaint governs. Even though it is a defendant or defendants who have this right of removal, the plaintiff's complaint governs. So since this statute states that only a civil action that could have been brought in federal court originally is removable, then the grounds upon which the defendant relies for removal must appear on the plaintiff's complaint. Remember, when we're looking if the federal court has subject matter jurisdiction, has original subject matter jurisdiction, we're going by the plaintiff's complaint. We're not looking at the counterclaim. We're not looking at the defenses. We're looking at the plaintiff's complaint. So this means that the grounds upon which the defendant relies for removal must appear on the plaintiff's complaint. Plaintiff sues defendant in state court on the basis of breach of contract, and defendant counterclaims with a federal question. Can defendant remove the case to federal court? And the answer is no. the court would not have had original subject matter jurisdiction. This case could not have been filed in federal court initially because remember, we don't go by a counterclaim when we're determining whether the federal court had subject matter jurisdiction. We go by the plaintiff's complaint. So even though defendant has a counterclaim with a federal question, the federal court would not have had original subject matter jurisdiction, and therefore, defendant cannot remove. On a similar note, a federal defense is also insufficient to determine grounds for removal. So a defendant cannot remove on the basis that she has a defense grounded in federal law, since the existence of a federal defense is insufficient to confer original federal question jurisdiction. Again, we don't determine federal subject matter jurisdiction based on a party's defense, based on the defendant's defense. We base it on the plaintiff's complaint. So if the defendant has a defense that is based on federal question, that is not sufficient to confer original federal question jurisdiction. And therefore, it's insufficient for removal. So here's an example. Plaintiff sues defendant in state court for breach of contract, and defendant asserts a defense that's based upon a federal question. Can defendant remove the case to federal court? And the answer is no, because the federal court would not have had original subject matter jurisdiction. This case, as you see it, could not have been filed originally in federal court, and therefore it cannot be removed. So just a reminder, we're still under the first prong. The case could have originally been filed in a federal court. Let's look at another example. Arizona plaintiff sues Nevada defendant in state court for breach of contract for $77,000. Can defendant remove the case to federal court? Yes. Here you have diversity jurisdiction. You have diversity of citizenship. The amount in controversy for diversity jurisdiction is met. So in this case, this lawsuit, as you see it, could have been originally filed in federal court. Now let's look here. Arizona plaintiff sues Nevada defendant in state court for breach of contract, and the amount in controversy is $75,000. Can defendant remove the case to federal court? The answer is no. To invoke diversity jurisdiction, remember that the amount in controversy must exceed $75,000. It can't just be $75,000. It must exceed $75,000. Now, having said that, I do want to add a note regarding the amount in controversy and diversity removal actions. If removal is based on diversity and the plaintiff is seeking non-monetary relief, or is for some reason not required to state an amount in controversy in her complaint, or if the recovery might be in excess of the damages stated in the complaint, then the defendant may state that the amount in controversy exceeds $75,000, and the district court may keep the case if it finds by a preponderance of the evidence that the amount does exceed $75,000. All right, now moving on to another example regarding diversity. Plaintiff from Nevada sues defendant also from Nevada in state court for breach of contract, and the amount in controversy is $77,000. Can defendant remove case to federal court? No, because to invoke subject matter jurisdiction based on diversity jurisdiction, there must be complete diversity of citizenship between the parties. And here we have two opposing parties that are from the same state, from Nevada. Now, I want you to note that since the plaintiff's complaint governs, a plaintiff can prevent a defendant from removing by simply failing to assert a federal claim or by joining a non-diverse party. However, after removal, the plaintiff cannot defeat jurisdiction by reducing the amount of the claim or by joining a non-diverse party. Now let's begin to look at the second prong. This second prong gives us a little bit of a caveat, because for cases removed on the basis of diversity, no defendant is a citizen of the state where the action is filed. So a Nevada plaintiff sues an Arizona defendant and a Texas defendant for breach of contract for $77,000 in a state court in Texas. Can defendants remove case to federal court? And the answer is no, because in removal, no defendant can be a citizen in the state where the action is filed. Now, I want you to keep this in mind because a lot of students miss this on their fact patterns. What about here? We have a Nevada plaintiff, we have defendants from Arizona and Texas. The lawsuit is for breach of contract for $77,000 in state court, and this state court is an Ohio state court. Now, never mind personal jurisdiction right now, we're only talking about removal. Can defendants remove case to federal court? And the answer is yes. No defendant is from the same state as the state court where the lawsuit is filed. Here, the state court is in Ohio. So we have diversity of citizenship, we have the amount of controversy met, we're good. What about here? I want you to distinguish. So here we have a plaintiff from Nevada, we have a defendant from Arizona, a defendant from Texas, and the state court is located in Texas. The lawsuit is based on a federal question and the amount of controversy is $77,000. Now, the answer here is yes, and I want you to distinguish this. Here, the removal doesn't have to be on diversity jurisdiction. You have a federal question. So a suit involving federal question is removable even by a resident defendant of the state where the lawsuit is filed. So even though defendant 2 is from Texas, it's okay for the defendant to be from the same state as the state court where the lawsuit is filed. So now let's look at the second part of the second prong. The prevailing rule is that jurisdiction is tested as of the date of removal. So what does this mean? It means that the right to remove is determined by the pleadings as of the time the petition for removal is filed. But there is an exception. Where diversity of citizenship is the basis for federal subject matter jurisdiction, the diversity must have existed at the time the original action was filed. Why? Well, this exception prevents defendant from changing the citizenship after the lawsuit is filed and then petitioning for removal on the ground of diversity. But I want you to distinguish this. If a case was not initially removable due to a non-diverse party, but plaintiff then drops the non-diverse party, the defendant may remove because the move was not within defendant's control. Why? Because in the above scenario, the change would not have been within defendant's control. It is not a situation where defendant is strategically trying to achieve diversity by changing her citizenship. So can the right to remove be waived? The answer is yes. However, courts are reluctant to find that there was a waiver, especially an implied waiver, even where defendants have appeared, have answered, and taken depositions in the state action. Waiver through contract, however, where the parties agree not to remove to federal court, is valid. Moreover, a state may not require a foreign corporation to waive its right to remove as a condition to doing business within the state. This is not okay. This is not allowed. So what happens when a lawsuit has removable federal law claims and state law claims? So whenever a separate and independent federal claim, which would be removable standing alone, is joined with one or more otherwise non-removable claims or causes of action, the entire case may be removed, and the federal district court may hear and determine all issues therein. What is the rationale behind this? Well, it prevents plaintiff from strategically defeating a defendant's right to remove by joining a non-removable state claim. And the purpose is to promote judicial economy and protect the defendant from having to litigate and defend two lawsuits in two different forums, state court and federal court. Now, some important points about this. Only those defendants against whom a federal claim is asserted must join in the removal. Also, the federal district court may remand the non-removable state claims if the state law predominates. The federal court has discretion to remand a case to state court once all the federal claims have been resolved, leaving only state claims over which there is no diversity jurisdiction. Moreover, I want you to distinguish this next situation, from the main rule. Where there's a single wrong or injury to the plaintiff for which relief is sought, arising from interlocked series of transactions, there is no separate and independent claim or cause of action under 1441C. What about venue in removed actions? The proper venue for a removed action is the federal district or division embracing the location where the state action is pending. And this is from 28 U.S.C. 1441A. Also, the general venue statutes are immaterial to removed actions. I want you to keep that in mind. Now, what happens if the original state court where the action is filed does not have jurisdiction? Previously, a federal court could exercise jurisdiction over a case removed from state court, but only if the state could have proper subject matter jurisdiction. Therefore, if the action was one with an exclusive jurisdiction of the federal court, for example, antitrust suit, the case could not be removed. The case would have been dismissed in the state court so that it could be refiled in federal court. But this cumbersome process is no longer necessary because of the passage of 28 U.S.C. 1441E. So now 28 U.S.C. 1441E expressly permits the federal court to take jurisdiction of the removed claim, even though the state court where the lawsuit was filed did not have proper subject matter jurisdiction to begin with. Okay, so what is the civil procedure for removal? I'm going to give you a quick summary. 28 U.S.C. 1446 is what governs the civil procedure for removal, the process. Defendant must file a verified petition. What is a verified petition? A verified petition is a formal written request to a court for an order of the court under oath taken before a notary public or officer authorized to take affidavits and to administer oaths, and 2, under a declaration stating in substance, I declare under penalty of perjury that the foregoing is true. So defendant must file a verified petition in the federal district court for the district and division within which the action is pending. The petition must contain a short and plain statements of the facts that entitle her to removal. Defendant must also file a copy of all process pleadings and orders served upon her, and a bond sufficient to cover costs and disbursements occasioned by removal, in the event, of course, the lawsuit is removed improperly. Defendant must give written notice to all adverse parties and must file a copy of the petition with the clerk of the state court. Now I want to talk just a little bit about timing. The notice of removal must be filed within 30 days after defendant receives notice, either through service of a summons, pleading, amended pleading, etc., that the case is or has become removable. If defendants are served at different times, however, and the defendant who was served later initiates timely removal, the earlier served defendant may join in the removal even though her 30-day period for initiating removal may have expired. I saw this on a test once, and I just want you to keep it in mind. Are there actions that are non-removable? Yes. Statutes prohibit removal in the following cases: Federal Employers Liability Act, actions against carriers for delay, loss, or damage in shipments where the amount in controversy is $10,000 or less, workers' compensation proceedings, some actions under Federal Labor Standards Act or the Securities Act for recovery for misrepresentation. So what happens if the removal was improper? If there was a removal but it was erroneous? If at any time before the final judgment, it is determined that the case was removed improperly and without jurisdiction, the federal court must remand the case to the state court and may order payment of costs. The remand to state court may be initiated by motion of either party or motion of the court itself. and the removing party bears the burden of proof upon any challenge to the removal of the action. Check out my videos on the other civil procedure subjects: personal jurisdiction, diversity jurisdiction, venue, federal rules of civil procedure. If this is how you're feeling after this lecture, please email me at questions@thelawschoolgirl.com.